minutes, so that let's wait for some more minutes, then we can start our program.
Okay, sir. No issues. No issues.
Okay. Just wait for 2-3 minutes more.
Okay.
Jaspreet sir, we will be starting our program from 3:35 p.m. onwards sharp.
Okay, sir. Thank you.
Am I audible and visible? Participants, am I audible and visible?
Yes, sir.
Okay. We are now starting our program. It's already 3:35 p.m. So today, Department of Civil Engineering, in association with Institution Innovation Council of GKCM, as well as the IPR cell of the same institute, is going to organize a webinar on IP for the modern academics. And to enlighten us, we have Mr. Jasprit Singh, founder of IP Quad, with us. Sir has completed his BTech in Computer Science from Punjab Technical University. And Mr. Jasprit Singh has started his career in IP at around 2011, and he has not stopped his progress in this particular section till now. Currently, he has more than 10 years plus experience. Mr. Jasprit Singh has trained more than 100 professionals in the patent writing, resulting in vast exposure to multiple domains like computer science, mechanical, telecommunications, cloud computing, AI, big data, product design, civil engineering, etc. So what I'm trying to say that our today's speaker, Mr. Jasprit Singh, has quite a vast knowledge in particularly the intellectual property rights section for most of the engineering departments. That is, whether it is civil engineering, mechanical, computer science, electronics engineering, or any other department. So today we are very lucky to have him here. So I am now handing over this session to you, sir. Mr. Jasprit, sir, please take out this session and deliver lecture, sir. Thank you.
Thanks, Sandeepan sir. Thanks for the introduction. So, as Sandeepan sir already introduced me to you, but it's my responsibility to have a brief introduction about myself. I'm Jasprit Singh from IP Quad Partners. Our company. I started this firm 3 years back, IP Quad Partners. So I have experience. I started my career in IP from 2011, 2012, and from last around 10 to 11 years, continuously we are working into this. And regarding the IP Quad Partners is basically a legal consulting firm that is basically helping out individuals, faculty members, startups, students to file their IP in India. So as this lecture is around getting the knowledge about intellectual property, so we are basically associated with around 20 to 25 colleges in India with whom we have a collaboration, and for that college, we are handling their intellectual property, basically various types of, we are handling various types of IPs. So today's session is basically on intellectual property rights. What is intellectual property? What are intellectual property rights, or different types of IP we will be discussing today. So without taking much of your time, let's start the session about intellectual property. I hope my screen is quite visible to you and my voice is quite clear to you. So at any point of
yes, sir. Yes, sir.
Yeah, at any point of time you feel
yes, sir.
that
audible and clear.
You want to ask any question, you have any doubts, you can raise your hand or you can unmute yourself and ask me question, because this webinar is for you. Because we were in talks with Sandeepan sir was in talks with me from last month. So due to my unavailability, I was not able to conduct this webinar earlier. So it's a kind of opportunity for you to clear some doubts regarding IPR. So let's start with the session. And the first one, what is intellectual property? We have around 30 to 32 participants in this webinar session. In a layman language, what do you mean by intellectual property? We have Sandeep sir, we have many other faculty members, students in the session. So if I ask all of them, do you know about anything about intellectual property? Have you heard about intellectual property? Anything about intellectual property, you know? Anyone, if anyone of you, if you can unmute yourself and answer this question. It can be anything. I just want to know the knowledge or what thoughts, your thoughts regarding intellectual property. What is intellectual property basically? Anyone from the audience, from the participants?
Intellectual property, as per my knowledge, so it's like whenever a person innovates something new, something innovation, then he has to put the rights and reservation of that particular innovation under his name. Otherwise, any other person can claim that particular innovation and use it for his own purpose and advantage. So if we don't have the intellectual property rights of that particular, then it will be a problem to identify his own innovations.
Okay, thanks, sir. Thanks for this short defined term. Intellectual property. Basically intellectual property is a kind of inventions, innovations, literature, arts, artistic drawings, anything, tangible, intangible creations. I'm talking about intellectual property only, not intellectual property rights. Intellectual property is a particular tangible or intangible creations by intellects. If you see around yourself, you have multiple IPs around yourself. You are using your mobile phone, you are using your laptops, you are using your automobile vehicles, you're using any mechanical product, you're using electronic appliances. All these are kind of IP, intellectual property, that is basically a tangible or intangible creation by any innovator or any inventor or any applicant. So any book, any product around yourself is a kind of IP. The spectacles you are wearing, the apparel you are wearing, the shoes you are wearing, all these are kinds of apparel. All these are kinds of intellectual property. So when I talk about intellectual property rights, so I divide this term into three: intellectual property and right. So in a layman language, when I say right is basically claiming something over your tangible or intangible creations. Property is a tangible assets. You have a property. What you can do from your property? You can sell it out, you can rent it out, or you can lease it out. Okay, so rights on property, claiming rights on your tangible property. And what do you mean by intellectual? Intellectual is basically a creation by some intellect. So intellectual property rights, the rights or the claims by the applicant or the intellect on their property. Property can be anything. Property can be any innovation. Property can be any invention. Property can be any your research article. Property can be any your photograph. Property can be any your artistic drawing. Property can be any your literature art. So intellectual property rights are the rights given to the applicant or the inventor or the owner for different types of IP. Inventions, brand names, software codes, drawings, architectural drawings, anything. All the things around yourselves are IP, and all these IP having some applicant or owners through which or to whom the claims or rights are given for a particular period of time. So rights is a kind of protection over your innovations or basically inventions. So if you have a property, what you can do from your property? You can rent it out, you can sell it out. By doing so, you enjoy the monetary benefits by using your property. Similar in this, in the terms of IP, if you have any protected IP, if you have any protected innovation, any protected invention, by protecting your innovation, by claiming IP rights over it, you can enjoy the royalties or monetary benefit by your invention. So intellectual property are the tangible assets or the intangible assets around yourself. Intellectual property rights are the rights or the claims over your intellectual property or your invention. So we have different types of IP. Today, we will be discussing few of them: copyright, trademark, design, patent, geographical indication, layout circuits, layout designs of integrated circuits, trade secret, plant variety. So today we will be discussing few of them. So that are basically important to your academics, to the faculty members, or the ones who are going for the startup, or the ones who are writing their research paper. So without wasting much time, let's start the first one, trademark. So in a layman language, if I ask anyone, what do you mean by a trademark? Anyone? What do you mean by a trademark? We have many mobile phones with us. We have many laptops with us. Every mobile phone, every laptop has a different logo or a trade name. Someone is using Dell, someone is using Lenovo, someone is using HP. So these are trademark. Trademark are basically a word or a phrase or a symbol or a logo or a basket, basically, or a combination of these, or for a tagline along with the logo. So a logo or a trademark or a phrase, trademark is basically a trade name, a mascot given to the company or the applicant or any startup for a period of 10 years. So it can be renewed before the completion of 10 years. That means every 10 years before the completion of 10 years, it can be renewed up to an indefinite period of time. So we have Nike, we have Reebok, we have British Airways, we have Canon, we have Nikon. So many trademarks are around yourself. If you have seen the front page of the slide, there are two trademarks. One is of GIS Group, second is of IP Quad Partner. So these are also a type of trade name, you can say, or trademark. So trademark is also a type of protection over your name, over your brand name, over your word or your symbol or anything that is related to the name of your company. So like in engineering colleges or schools, we have different classes for different subjects. I take example of 12th. We have different section for arts. We have different section for commerce with maths, or commerce without maths, commerce with physical education, or non-medical, medical with non-medical with computers, non-medical with physical education. So in schools also we have different classes related to different domains. Similarly, in trademark also we have 45 classes, like 41 classes. GIS trademark falls into 41 class, that is education providing of training, entertainment, sporting or cultural activities. Like we have a trademark in class 45 that is related to legal services. For financial transaction, we have class 36. For chemical industry, we have class 1. So there are total of 45 classes in trademark. So each and every class, every trademark is associated with a trade class. Suppose GIS is having a trademark in class 41 that is there, and class 41 says that anything that is related to education industry. So GIS got a trademark. Now the same GIS group want to use the similar trademark in different class. Can they do that? Can the owners of GIS group can use the trademark which is in the class of 41, which is in the class of education, can use the similar trademark without can use the similar trademark for apparel section? Okay, so I want to know from you that can we use that as a trademark in class 41 that is for education industry? Can we use that trademark in apparel industry? A question for you. I will answer this question after the completion of this particular trademark type of IP. So few example, Pepsi Ye Dil Mange More, Mentos Dimag Ki Batti Jala De, Havells Shock Laga Kya. A trademark with a tagline. A trademark with a tagline. Maggie Taste Bee, Health Bee. All these are types of trademark. So when we are filing a trademark, we have to keep in mind that similar pronouncing names or homophones won't be getting a trademark. Suppose Sandeepa sir filed a trademark into the apparel industry with the, oh, I take this example that I take one example. You can see on your screen that trademark with a name of empty. Now I remove E from the starting. Again, if you pronounce it empty. Now I am removing Y from the last. Again, we pronounce it is empty. Now I am removing P from the middle. Again, if I pronounce it empty. So all these four trademarks, if you pronounce it empty, 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 empty. Similar in the name of Sandeepan sir. Sandeepan sir having a spelling of their name Sandeepan. So I'm using, if Sandeepan sir, you want to use Sandipan, he can file for a trademark, but he won't be getting a trademark for that because similar pronouncing names won't be getting a trademark. You won't be getting a certificate for similar pronouncing name in a similar class. Okay. So I was saying that similar pronouncing name won't be getting a trademark. Okay. So how come, if you see the right side, top right side of my screen, two trademark with similar pronouncing theme or homophones, how come BlackBerry into the apparel section got a trademark, whereas BlackBerry into the electronic section was already there? How come BlackBerry into the apparel section got a trademark? Anyone can answer. If anyone can answer my question, how this trademark BlackBerry was granted a certificate? If you pronounce both the trademark, both are BlackBerry. So how come they got a trademark? Anyone? Many participants are there. Anyone can answer. If anyone want to answer this question, how come BlackBerry into the apparel section got a trademark, whereas BlackBerry into the electronic section was already there? We have many participants. If they want to answer this question, I will be doing that, but I want your inputs too, because it's a two-way communication to have some interaction level with you also. So anyone can, if anyone wants to answer this question. Okay, let me answer this question that BlackBerry into the apparel section has a different class, and BlackBerry into the electronic section is a different class. So the BlackBerry into the apparel section was not affecting the business of BlackBerry into the electronic section. Both the parties have different domain. One is into the apparel section and one is into the BlackBerry. One is into the electronic section. Okay. So I ask you one question, that if GIS having a trademark in class 41, can they use the similar trademark for the apparel section? Can they use that? The answer is no. The reason is that GIS having a trademark in class 41, not apparel section. For using the similar trademark into the apparel section, GIS has to file separate trademark for apparel section. That is why for every different domain, you have to file separately. If you want to use GIS in chemical industry, you have to file it separately. If you want to use in household appliances, you have to file it separately. If any kind of legal services they are providing, you have to file it separately. So for every domain, you have to file your trademark separately. So few other example, trademark infringement example. PayPal filed a case against Paytm. If you can see, the PayPal accused Paytm that they are using the same kind of logo, that is a color combination of dark blue plus light blue with initial, that is pay. So that is based on this, the business of PayPal quoted that Paytm was using the similar kind of logo, and due to which the business of PayPal is being affected. So the case is still going on in the Indian Penal Code. Another case is Oreo versus Fabio. See the similarity between the two products. So Oreo filed a case against the to the owners of Fabio that they are using the similar trade dress, and due to which the business of Oreo is being affected. So trademark is not only related to trade name or name also. They are basically into trade dress also. Someone is using the copy of Haldiram Namkeen. Someone is using a similar kind of trade dress of Pepsi or Coke. So these also fall into trademarks. So representation of your name. Saurabh. Similar pronouncing name, but if we write it, it is quite different. Bilsleri, Bisleri, Bristly. Nika, just do it. Nika, must I make do it. McDonald's and McDonald's. So these are quite known and familiar trademark examples, trademark infringement example that you come across in your daily life. There is one more topic I have not mentioned here, that is brand enforcement. In brand enforcement, when we do online shopping on any e-commerce website, Amazon, Flipkart, Myntra, suppose you come across any footwear, Nike footwear. So the cost of that Nike shoes is around 5,000 on any e-commerce platform. The similar pair of shoes are available on any store with a cost of 7,000 or 10,000. So brand enforcement is a term in which someone is using some popular brand name and selling out their own product. Someone is using the name of Nike and selling out their own product on e-commerce website. Someone is using the name of GIS groups and coming out with some some educational institute or coaching institute. That is brand enforcement, that someone is using your quite popular trademark or popular brand name and selling out their own services. So this was trademark, the term of a trademark, and what are the limitations of the trademark, and what are the basic trademark infringement example. Anyone having questions regarding trademark?
No, sir. I think you please go ahead.
Okay. Another type of IPR is copyright. Basically, this type of this is also a type of protection that is given to the applicant or the research person or any writer on their literature art or on their artistic work or any other poem, songs, basically kind of literature art. Copyright is a type of intellectual property that is in which rights are given to the applicant for their songs, music, advertisement, cartoon characters, books, research papers, and novels, movie writings, songs. All these are covered into copyright. So the term of copyright is the life of the person plus 60 years. So the term of the trademark was 10 years, and the life term of copyright is basically life of the person plus 60 years. So I can quote one example that Amitabh Bachchan is still using the poems of Harivansh Rai Bachchan, because the duration or the term of copyright is quite a lengthy one. So for copyright, we cover artistic recordings, dramas, musical composition, musical writings, literature. All the things are being covered in copyright. So few trademark infringement example. The director of all of you have seen Ujjwala Chaman and Bala. So Ujjwala Chaman and Bala were quite having a similar storyline concept. So the makers of Ujjwala Chaman filed a case against the maker of Bala and quoted that they were in discussion with the makers of Bala, and but without taking consent or from the makers of Ujjwala Chaman, the makers of Bala comes up with the similar type of storyline, similar type of movie, and in the name of Bala, due to which a loss being occurred to the makers of Ujjwala Chaman. So some royalties were being paid to the makers of Ujjwala Chaman by the makers of Bala. Another incident was, if you see at the right side, the similarity between the two posters. So one is of the movie Judgmental Hai Kya, the other one is basically an artistic work by an European artist, Flora Bossi. So this is also a kind of copyright infringement work. So you have multiple online platform that provides you live streaming of your music. So as music basically is a kind of IP that is basically given, the rights are given to the industry. Tips industry is there, T-Series is there, and Yash Raj music banner is there. So all the music are basically having all these music company having some rights over it. Similarly, Tips was having some Tips industry is having some rights over their content. So Wink Music, Ghana app, all these are online platform. So what Wink Music did was they had an agreement with tips industry that they will play the music of tips industry on their online platform, on their Wink Music app. That is too free of cost. But in the agreement, it was not written that the Wink Music or the Wink app will allow the user to download the music of tips industry, that too free of cost. So the royalties were being paid by Wink Music to the tips industry because the content of the tips music, the content of the tips music or the songs of the tips music were given to the subscriber of Wink Music, and that is free of cost and without taking consent from tips industry. So suppose you are having any research article, any book, anything that you have right over it, and someone else is using your content without taking consent. So you can file a copyright infringement case against the person. I can quote one more example that many PDF versions of books are available over the web. That is too free of cost. So the owner of that book can file a copyright infringement case against the ones who are giving that PDF version of their book. So basically, if someone is using your content, someone is using your music, someone is using your any literature art, someone is using your poem, someone is using your any published article without taking your permission, you can certainly file a copyright infringement case against them, and you can certainly ask for royalties or monetary benefit that the person is having by using your content. And your content can be anything. Your content can be your drawing. Your content can be your any cartoon character. So anything can be there. I can take one more example. We have many at marriage functions or any event, we used to play or we are playing many songs, Hindi, Punjabi, Bengali songs. Many songs are being played, but ethically it is not allowed because we have to take permission from the owners of the content, the ones who have composed it or the ones who are having the rights over that music. So if someone is using your content without your consent, you can easily file a copyright infringement case. So in this, you can protect anything that is related to your research articles, because as you are almost all faculty members are there, or students are there, or research scholars are there. So even you can protect your research article via copyright. Any questions regarding copyright, or shall I proceed?
Please proceed, sir.
Okay. Now comes the main two topics of intellectual property right. First is design and second is patent. So what do you mean by design in a layman language? If I ask you, what do you mean by a design? What do you mean by a design? Not drawing, a design. In engineering or any technical qualification that you have or technical education, we have a subject known as ED, engineering drawing. In ED, we say that every product has 7 views. And those 7 views are perspective, front, back, right, left, top, bottom. Similarly, in design is also a type of intellectual property rights that are given for the overall appearance of the product, the structure, the shape of the product. You have mobile phones with you, everyone having different mobile phones. Someone is using Apple, someone is using Samsung, someone is using Oppo. If you see your mobile phone or the mobile phone, there is some difference between the mobile phone. Someone having round edges, someone having curve edges, someone having power power button at the right, someone having at the left, someone having volume button at the right side, someone having at the left side, someone having a camera position at the middle of the phone, someone having at the right side, someone having at the left side. So the appearance of the product, not the functionality. Not the functionality. You have multiple SUV vehicles or hatchback vehicles, or many two-wheelers are there. So the difference between the design, not the functionality. Again, a design is a type of IP in which we cover the overall appearance of the product, the overall appearance of your mobile phone, the overall appearance of your laptop, not the functionality of your laptop, not the features of your laptop, the overall appearance of the laptop, the overall shape of the laptop. So this type of IP in India is protected for a period of 15 years. Design of a tire, design of a stroller, design of a shoe, design of a handbag, design of SUV vehicles, Ford, Infiniti, Nissan, Hyundai, Porsche, BMW, Toyota. See the difference between the design. Again, I am saying, not the functionality. A chair with a 4 leg, a chair with a 5 leg, a chair with a 6 legs. So what is the purpose of having the 6 legs? In design, we cover the unique shape of the product, not the functionality. So if you are coming up with a design, you can file a design patent in India in which functionality is not being covered. The appearance of the product is being covered. A design of a bag, a design of a frame, a design of a shoe, design of a Visa card, design of a dustbin, design of the apparel you are wearing, design of the cutlery that you are having at your home. So in design, we cover the overall appearance of the product. The protection is over the design, not the functionality. So Apple, one design infringement example, that see the similarity between the two products. One is Apple was having a design patent, and the right one is Samsung Galaxy series. So Apple was having a design patent for their iPhone series. So Samsung copied the design of Apple, copy the protected design of Apple, and see the similarity between both the products. Round curved edges, the internal structure of the mobile phone. So Apple filed a case against Samsung in 2011 and quoted that the similar design of Apple is being used by Samsung, due to which the business of Apple is being affected. So royalties of $399 million were paid by Samsung to Apple. But why $399 million was being paid to Apple? Because their design was protected. The design of iPhone series was protected. So there was a similarity between both the products. That is why somehow the business of Apple was being affected. So Apple filed a case against Samsung for design infringement. So if you are having a design and someone else is using the same product, similar type of product in terms of design, not features, you can file a design infringement case. Another case was filed by Crocs Inc. against Bata, Liberty, Action, many other Indian firms, and quoted that Crocs Inc. is having a patent from 1992 in India. But the Indian Penal Code rejected the case of Crocs Inc. and quoted that Crocs registered designs are not new in India. Similar type of products were already available before the period of 1992 in India. And this is not something new that they have invented. So the case was rejected by the Indian Penal Code of Crocs Inc. versus six Indian companies, six Indian footwear companies. So when I talk about design, I only talk about the appearance of the product, not the functionality of the product. So anyone having questions regarding design? What is design? What are being covered in design? Any questions regarding design?
Participants, do you have any query? Sir, please continue.
Okay. Patent. This is the main thing in IPR, intellectual property rights. The base or the main thing that is related to faculty members, academicians, students, startups, to everyone. This is the most important part of intellectual property right. Patent. A patent is basically an exclusive right given to the applicant or inventor for a period of 20 years for their invention. 20 years, protection of 20 years on your invention to the applicant. The invention can be a process of making infrared heaters, a machine for making infrared heaters, and an article. The article can be infrared heaters, a composition, or any improvement over the existing art. So when I talk about an improvement, so here I take one example. I came up, there was a dyeing machine. A dyeing machine was there that was working on 100 degrees Celsius temperature. Now I come up with an improvement and I'm saying that similar design, a similar dyeing machine is now working at 30 degrees Celsius temperature with an efficiency of 5 times from the conventional dyeing machine or from the past dyeing machine. So what improvement I have done, what new features I have introduced in my previous art that makes the dyeing machine working at 30 degrees Celsius temperature now. So what new thing I have invented? So basically, patent is for anything that is new, that is unique, that is novel, that is new to the public, that is new to the public, and it can be anything, any machine, any process that you have developed that was not there. Anything can be there. So a patent is an exclusive right for a process, machine, an article, or a composition, or any improvement over the past invention, over the prior invention. What are the requirements for having a patent? First, non-obvious invention. Non-obvious. When I talk about non-obvious, that means any new invention is not arrangement or rearrangement of something. Some new results are there, some unexpected results are some unexpected results are there for your invention. So suppose a system A with a system element 1, 2, 3, a system B with system element 4, 5, 6. So you can't come up with a system C that are having system element 1, 2, 3, 4, 5, 6. So arrangement or rearrangement something, it is quite obvious. So requirement of patent, first requirement of a patent, that is non-obviousness. Non-obviousness, that is not basically mixing of something, rearrangement of something. Non-obviousness is basically something new. Second feature is novelty. What is the novel feature that you have introduced in your invention? What is the new feature that you have introduced in your invention that makes it novel? What I have done in my dyeing machine that is now working at 30 degrees Celsius temperature. Someone is coming up with a robotic machine. How your robotic machine is novel? How your robotic machine is quite different from the other robotic machine that are already available. If you are coming up with some attendance system, how your attendance system is quite different from other already available attendance system. If you are coming up with some mechanical tool, so how come your mechanical tool or how come your any process that you are using in any machine is quite different from the already available process or method or any article? So what is the novel feature of your invention? Second, third thing, utility. What is the functionality of your invention? In design, I was saying a chair with a 4-leg, chair with a 5-leg, a chair with a 6-leg. But in patent, we say what is the functionality of your a chair with a 5-leg, a chair with a 6-leg, a chair with a 7-leg. So in design, we don't cover the functionality, but in patent, we cover the functionality also. Why are you using a chair with a 4-leg or chair with a 5-leg or chair with a 6-leg? So requirements of a patent is basically non-obviousness. That is something new, novelty. What is the novel or unique feature that you have introduced that is making your invention quite different and quite unknown from the previous art? And the third is, what is the utility of your invention? What is the functionality of your invention? So that is why we say design patent and utility patent. In utility, we say the functionality. In design, we cover the overall shape of the product. In design, we don't cover the process. In design, we cover only the shape of the product. Any product, any XYZ product is there. So the design of the product is being covered. But in patent, we cover the functionality or the utility feature of your invention. So basic patent filing procedure in India. First, you have to file a provisional that is incomplete or a non-provision that is complete. A provisional, a complete or incomplete specification in the Indian Patent Office. So when you are filing incomplete specification, Patent Office gives you a period of 1 year to file your complete specification. After filing a complete specification or after filing a complete specification, within a period of 18 months, your patent application is being published in the patent journal. After publication, you have to request for examination to the Indian Patent Office. And after filing request for examination, your patent application is being examined by the examiner at the patent office. After the examination, the examiner will quote some objections or rejections related to your patent application. So by doing so, we have to reply, or patent agent, or you, the applicant or the inventor, have to reply to the patent agent regarding the objections or the rejection that examiner has quoted. So after some hearings or objections, your patent application is granted or rejected based on the novelty of your patent application. So this whole process, or this whole conventional process, takes a period of 3 to 4 years. But there is an expedite way also. Suppose you file your patent application on 1st of July 2022. It can be published within a month also by filing a certain fees. And after publication, you can request for examination and your patent will be examined within a month also. So the result of your patent application will be there, or whether it will be granted or rejected will be there within 3 to 4 months. But for this, there is a fee associated with it. In conventional way, there is a normal fee, but in an expedite way, there is some additional fees that is being paid to the Indian Patent Office. And after that, your patent application will be examined in an expedite way. So this is basically patent procedure in India. So India's first patent was granted in 1856, a mechanical pankha pulling system. The first patent, first, second, third patent was granted to George the Penning in 1856. So in 1856, India's first patent was filed. And at that time, this invention was quite novel or new. Similarly, Sony filed a patent application in 2022, and they are coming up with a technology that in which you can convert your nearby appliances, handheld appliances, into remote, into a gaming remote, a fruit into a remote, a mouse into a remote, any joystick into a remote, any mic into a remote. So Sony is coming up with this technology. Apple filed a patent application of single glass desktop with detachable keyboard. Quite a novel one, a unique one, a single glass desktop with detachable keyboard, filed by Apple. Harideshwar Singh of India was the youngest patent holder. He invented 6, 12, and 60 player chessboard. Quite a novel one. So the age is also a limit. The complexity is not the limit. We need just an invention that is quite unique or quite new to the world or to the general public. Dyson is coming up with air purifier headphone that will purify the air that is coming onto your face. Another is in design. I covered design infringement, and this is patent infringement. In design infringement, Samsung copied the design of Apple. In this, Samsung copied the inventions of Apple. We use bounce back scroll, we use tap to zoom, we use scrolling with one finger, but all these inventions were invented by Apple in 2004, 2005. So Apple in their Galaxy series used these inventions, used these patent number 7469381 7844915 and 7864163. So all these inventions, all these innovations at that time were used by Samsung without taking consent, without taking license, without taking permission from Apple. So Apple, along with the design infringement case, filed a patent infringement case in the US. So for that, Samsung paid a royalties of $539 million to Apple. So Apple got royalties of $339 million for a design case and $539 million for a patent case. There are some myths regarding the patent that it is compulsory to have a prototype. Patent office need an idea, not your prototype. What is your idea, how it is working, how it is not from the other available resources or the products or the services or the methods. Getting a patent is a big task, not at all. Basically, your idea should be the novel. Many consulting firms, many patent agents, many individuals are there who can help you out to get a patent. But for that, you need to have your novel invention, because the consulting firms like us will help you out to draft your patent application, to help you out to dig out some references, past references that are already there, so by which you can mold your invention accordingly. So getting a patent is not at all difficult. Only domain-specific applicants can apply. Anyone from anywhere or any person from any domain of any age can file any patent application. Patents are enforceable worldwide. If you have a patent in India, that is only enforceable in India, not in the US, not in any European country. So if you want to enforce your patent in other countries also, you have to file it separately. While you are using your system, you open a new tab using a right click. So open a new window. That is basically a patent, Microsoft having a patent over it. We are using Flipkart, Amazon, and we use one-click buying tool over there. So that is also a patent by Amazon. Michael Jackson was having a patent for his anti-gravity footwear for his favorite dance move. So that allow him to bend at certain degree. So anything complex or technical, non-technical inventions can be there. Some funny or weird examples are there. A device for holding the mustache out of the way in eating or drinking. Animal ear protection for protecting the ears of the animal when the animal is basically having a lunch or dinner, so that the hair don't fall into the food, and self-congratulatory patting device that you can congratulate yourself if someone is not doing so. So many inventions are there. One person from Mumbai, Subramanian Naidu, has invented a product that is known as LED pet collars, and Ratan Tata funded that invention for 14 crores. So any weird invention can be there. If I take one example, uh, many Zulu bikes are there in the market. That was also a kind of idea, and it is not, and it is being running successfully in Delhi NCR. So many startup idea, many weird ideas can be there. I can take one example of mask. If before 2019, I hardly know anyone that who was using some mask or sanitizing machine. But after that, the ones who have invented, or before 2019, the one who invented sanitizing machine or these N95 masks are enjoying the royalties right now. So basically, patent is basically a kind of protection to your invention for future prospect, not for 1 or 2 days. If you look uh, at around yourself, we use automobiles. In automobiles, we use that airbags, but airbags, uh, when the first airbag was invented in 1970 or something, mobiles were invented in 1971 or something. So at that point of time, every company was having rights over it, and they are now enjoying the royalties for such invention. So if you have anything related to uh, your domain, civil domain, or you have anything related to your mechanical domain, or not only to your specific to your domain, anything related to your invention that you think that is quite novel, you can certainly file a patent application over it, and you can look for investors or funding from the company, from taking help from your college, or we have also some investor or funding possibilities there. So, but for that, you need to have your patent application protected or your invention protected, because no one will invest in something that is not protected. If I talk about intellectual property, if I talk about uh, today's environment, everyone, if you have seen Shark Tank and all these tech startups, everyone tries to protect their idea first, then look for investors. So basically, patent is the main thing or the core thing of intellectual property, because you have to protect your idea first. After that, anyone will invest in your idea. Some non-patentable inventions are there, that is quite obvious. Something that is injurious to um, life of animal, human. Something that is a discovery is not patentable. Something that is a method of horticulture or agricultures are not patentable. That doesn't mean that machines related to horticulture or agriculture are not protected. खेती करने का तरीका, everyone has a different way of doing cultivation, so that is quite not patentable in India. Arrangement or rearrangement of something is not patentable in India. Along with that, any business method patent is not patentable in India. That is the reason why many apps are coming out. Many 2 minute delivery apps are coming out, because in India, business method is not patentable. Many food delivery apps are there. Zomato is there, Swiggy is there, many other are there. Uber was also doing the same thing. Many traveling cabs app, car apps is also there. Many apps are there. So these are not patentable in India. That is why many apps are, day by day, many apps are coming in India. Second is, again, any algorithm is not patentable in India. Method of playing game, method of presenting the information is not patentable in India. Anything related to atomic energy, rare earth material is not patentable in India. Anything related to production or production of animals, plant, or human is not patentable in India. This non-patentable items are totally related to India only and nothing else. In many other countries, some things out of this are patentable, but in India, these things are not patentable. So anyone having some questions regarding patents? Anyone?
Participants, if you have any question or query regarding today's session, I would like to take some questions from your end. Our speaker, Mr. Jasprit Singh, would like to answer those. So if you have any query, please feel free to ask. Jasprit sir,
Yes.
Until we are getting any questions, so I have a query.
Yes, sir.
Hello.
Yes, sir. Yes, sir.
Okay. So, sir, basically, how long does it take for the approval of a patent, particularly in India?
Sir, in a conventional manner, it takes around 3 years, 3 to 4 years in India. And in expedite manner, it takes around 4 to 5 months, depending upon how quickly you are responding to the patent office. So,
sir, basically, as we have shown, like there are several kinds of IP, like patent and copyrights, design.
yes,
So
yes.
all those take the similar kind of time, or they
No,
have
sir. No, sir.
Time?
Sir, sometimes copyrights is being issued. Copyright certificate is being issued many times in 2 months, also in 3 months, also. Sometimes it takes 7 months, also 8 months, also, depending upon the clearance of the clearance from the copyright office. When I talk about trademark or design, similar in that case also. If some objection is there, then it may take time. Otherwise, 4 to 5 months, all the things are being cleared. And in design also, if there is an objection, then it takes time. Otherwise, within 6 to 7 months, it is being cleared. So that is basically if you are responding to the particular IP office quickly. If suppose you have filed your trademark or design application on 1st of July, within few days, within a month, a response from the design office comes out, and they give you a period of 6 months to reply. It totally up to you how quickly you are responding to them. If you take 6 months to reply, then the period of granting the design certificate will take time. Similarly, in case of copyright, also in trademark, also, how promptly you are replying to them, because the more efficiently or the more quickly you respond to them, the less will be the time taken by that particular IP office.
Okay, so sir, as I can understand that actually the timeline is different, but also it requires what I mean to say, like whether it is a copyright or patent or design application, all needs proper documentation. Otherwise, it takes more time.
Yeah, sir. Along with the documentation, if I talk about patents, we say that you need to describe all the things in your patent. If you are coming up with a unique invention, okay. Along with the patent, sometimes examiner asks you a question. How come they comes up with some references that they think that they are related to your invention. So we have to make them understand how your invention is different and how those patents that were found out by the examiner is not exactly the same as your invention is. So how smartly you draft your application, and how you provide all the documents regarding various type of IP. If I take a case of copyright. Okay, so they need each and everything that is being described in your research article. Suppose if I take example any computer section, they want there should be some there should be all the there should be all the information, what languages are used, what platforms are being used. We need to provide each and everything, because these are the types of objection that we receive from every type of IP office. That what is this invention? The title may not suit the type of content you are provided. So these are basic inventions, basic objections or rejections by the respective offices.
Okay, sir. Thank you, sir. So, participants, if you have any query, please feel free to ask, or you can write it at the chat box.
Okay, let me close. Let me finish this last type of IP.
Okay.
Then we can have a discussion over it. Okay.
Okay.
So this is the last type of IP, that is trade secret. A trade secret is basically gaining a competitive edge filed by a company. That means we have many noodle products are there. Maggi is there, Zing Chinese is there, Yippee noodles is there, but they have some different tastes if we compare all of them. So a copyright, a trade secret is a kind of agreement that is being signed between the native country, and the company to not to disclose their invention to gain a competitive edge. We have many cold drinks available in the market. Pepsi is there, Coke is there, Thumbs Up is there, but there is some difference. We have many that search engines are there. Google is there, Bing is there, Yahoo is there, Firefox is there. But all the search engines have some different algorithm that is running on the back end. We have McDonald's is also there, Burger King is also there, KFC is also there. But there is some difference between each of them. So a trade secret is kind of competitive edge. The company filed a trade secret with the native government to not to disclose their invention. Along with that, I want to say that you won't be getting any, if you, there are many tools, many search databases for patents, but you won't be getting any patents related to weaponry art. You won't be getting any patents to anything related to the products related to army or any that is the kind of ammunition. You won't be getting that, because you won't be getting patents that are being filed by DRDO, because that is quite confidential. They don't want to disclose their invention. If you see, you won't be getting any Russian weaponry art patents. So that is how they try to hide their inventions that is quite complex and quite unique, and based on that, they want to have a monopoly in the world regarding such invention. Maybe India must be having some invention. I take one example of the COVID vaccine. So no one wants to disclose the formula or the composition of the COVID vaccine, because everyone wants to claim that their COVID vaccine is quite high efficiency as compared to the others. So but how can they do that? They can do that basically by filing their patent application. If you have something related to any sanitizing machine or any drug that you think that that is quite efficient for reducing virus, so you may go for a patent application. But you can also claim that you won't be disclosing it to the general public. Once your patent application is filed, you can look for the companies or the investor who can invest your in ideas, and you can also have a monetary gain by using your such XYZ invention that may be helpful to the public, but in monetary terms, it will be helpful to you also. And along with that, we have single product, multiple IPs, a single your vehicle have some design that is comes under design patent, the functionality comes under patent, utility patent, the basic name of the vehicle comes under trade name or brand name or trademark, and this is single product, multiple IPs. At the right side, we have the design of washing machine, the trade dress of Haldiram. Along with that, we have multiple novels that are being converted into the movies, but they filed the protection, they filed the copyright, due to which the royalties were being paid to Chetan Bhagat for their novel, for using their content. Similarly, we have a single product that is mobile, having different types of IP. First, the trademark overall design comes under the design patent. The functionality, the camera functioning, or the features come under the patent. So, single product, multiple IPs. So, how we are helping out the industry, how we are helping out the college students, that we take ideas from the colleges and we try to file their patent application or design application or trademark or copyright in respected offices and help them to draft the patent application, and basically a kind of consulting. You don't have to do anything. It's that we will be drafting for you, we will be searching for you, we'll be filling the forms for you. What you need is to provide us the basic information regarding any kind of IP that you are going for. So we will be helping you out. We are helping out many colleges, many students, many professors in India. Along with that, if you have any doubts regarding intellectual property, IP rights, types of IP, or patents, or anything related to patents, anything, you can ask me right now, or you can have my number, you can mail me, or what you can do, Sandeep sir is also planning some offline session, because in an online session, we don't have that interaction level as in offline offline section. So Sandeep sir is also planning a offline section that will be in your at your campus. So by then you can ask me question. But if you have anything, any doubts related to your invention, related to this session, or related to copyright, trademark, patent, design, anything, you can ask me right now, or you can ping me separately over my mobile number. So I request you to don't hesitate in terms of asking your question, anything related to this session. If anyone having, please, it's time to discuss the queries or the questions by you, please.
Participants, you have any question, please feel free to ask. Mr. Singh, I think our participants for now, they don't have any particular question. So I think all of have already marked down your contact details and other details that you have shared with us. So I'll just go through some queries from their end after this session, and if I find any query from their end, then I'll mail it to you, or I'll send you details so that they can contact you directly, sir.
Sure.
So with the permission, today we are concluding this session, but definitely we will be meeting soon through an offline session as well as in person level also, sir. So thank you, sir. And really, it has been a very good session for us, because as you have shared the basic knowledges regarding IP and how it how we have to apply and what is the procedures and what the distinctions between all those types of IPs. So it's a very good to know knowledge. As India is also performing a great deal in particular in this sector. Kindly, there is a report has been published that India is currently 42nd, holding the 42nd position in terms of innovation. So now innovation comes from for even grassroots also, because as you have already shown a particular example of a 9-year-old boy who has a patent for 6-player chess game. So I would not like to take any more minutes, and here today I am concluding session. And participants, I hope you have marked down your Jaspreet sir's contact details. So if you have any query regarding IP or IP filing, you please contact sir directly. Or you can post your queries to me also, then I can convey the messages. Sir, before the conclusion, I'd like to share something with your permission. So, sir, basically, just a second, sir. Just a second. Actually, I have a memento for you, sir. Return memento, as it's a Green India concept is ongoing. Sir, can you please, is it visible, sir?
Yes, sir.
It is our gesture. It's a token of gesture from our end, sir. And I will mail it to you through email.
Thank you, sir.
So, thank you everyone for being here today. And I would like to thank all of my colleagues from Institution Innovation Council of GKCM, as well as IPR Cell and Department of Civil Engineering for their endless contribution to make this event a success. And also I will thank IP Quad for their valuable time for this enlightening session. And last but not the least, I would like to thank Dr. Mahua Das, Principal GKCM, for her endless support and guidance for organizing this session. Thank you, sir. Thank you, everyone. And thank you to all the participants here. Thank you, sir. Okay, by myself, Sandipan Saha. Hereby I am concluding session for now. Thank you, everyone.